as by the eminent jurists on the Constitution. From the language of Article 189 and 190 of the Constitution, it is concluded that opinion expressed by the Supreme Court in a reference under Article 186 is required to be esteemed utmost by all the organs of the state. Therefore, it would not be fair to say that the opinion expressed by the Supreme Court on presidential reference under Article 186 of the Constitution has no binding effect. No, sir, this binding effect is of this honorable court. So, sir, इसीलिए मैं अर्ज कर रहा हूँ कि सर सुप्रीम कोर्ट है, यू आर अ पार्ट ऑफ द सुप्रीम कोर्ट.
But there is no express language in this presidential reference to say that it has binding effect come what may.
ये ओपिनियन
और ये इंडियन जो रेफरेंसेस हैं उनमें ये बात जरूर, उनमें भी ये बात लिखी हुई है कि उसको वो कहते हैं कि इज रिक्वायर्ड टू बी गिवन सम एस्टीम कि सुप्रीम कोर्ट एक ओपिनियन दे रहा है तो आप उसको कुछ जो है उसकी वैल्यू है.
ये ओपिनियन
कहते हैं इट इज नॉट फेयर टू कंक्लूड, ये है कि ये बात मुनासिब नहीं है कि इसको आप कहें कि भाई ये बाइंडिंग नहीं है. बट ये वरना वो लिखते कि 189 में बाइंडिंग है, वो 189 का
बहरहाल बहुत उन्होंने इस पे जो वेट दिया है और ये व्यू चेंज नहीं हुआ आपकी कोर्ट का बाद की किसी और.
ठीक है, आप ये इस रेफरेंस में भी इसका डिस्कशन है. ये अभी जो लेट जुल्फ़िकार अली भुट्टो रेफरेंस था उसके अंदर भी इसका रेफरेंस का भी जिक्र है. मेरे अपने नोट में भी है, औरों के भी नोट में भी.
जी जी ठीक फरमा रहे हैं. अब मैं सर रेफर करूंगा सर PLD 1963 Supreme Court 486 relevant page 511 and 512.
511
My lords, in this judgment,
ये उठा लो दोनों किताबें से उठा ली.
511. Sir, when late President Ayub Khan promulgated and gave our Constitution of 1962, so it was a presidential system. President was exercising several legislative powers, which he was conferred under then Article 24 of 1962 Constitution. Now, sir, by using those powers, the President made amendment in several articles of 1962 Constitution. And one which became more controversial was that under the presidential system, sir, a member of the National Assembly cannot be a minister of President's cabinet. And if such member becomes, so he loses his seat in the National Assembly. But one of the amendments which created more hue and cry was that amendment was made whereby minister could keep their seat in the National Assembly as well as their seat in the cabinet. तो सर मैं थोड़ा सा मुख्तसर सा पढ़ूंगा. तो ख़ास तौर पर जैसे यहाँ बात हुई थी कि जब अमेंडमेंट हो जाती है तो it becomes part of the Constitution, no doubt. But sir, when it is a challenge, when cognizance is taken by the Supreme Court, then when it cognizance is taken, then sir, those impugned amendments or their validity becomes subject to the outcome of the decision of this honorable court. And that is what happened here. I would read, sir, the last para from the page 511 if the conclusion be that the adaptation made were not within the power, since their effect and purpose was to alter the very nature of the Constitution. The reason given for the change would seem to lose importance. The expression necessary and expedient appears in the preamble as it does in clause 3 of Article 224, but in the later clause, the necessity and expediency must be for the purpose of removing a difficulty, one of the expressed kinds. Here the expediency and necessity were for producing an effect contrary to that clearly stated in the Constitution, and not for the purpose of bringing the Constitution as it was granted to the country into operation. The preamble states that the members of the Assembly had expressed unwillingness to become ministers if they were to cease to be members. Presumably, as members, the gentlemen in question had taken oath to preserve, protect, and defend the Constitution, and their insistence that the Constitution should be altered before they became ministers would seem not to have taken sufficiently into account the solemnity of that oath. The impression is clear that and unavoidable that ground of expediency was based on a desire to accede to the wishes of certain persons, probably a fairly small number of persons, but the Constitution was not intended to be varied according to the wishes of any person or persons. Anything in the nature of the respecting of persons, unless provided by the Constitution itself, would be a violation of the Constitution. And if the Constitution were itself altered for some such reason, and that in substantial and not merely a machinery aspect, there would clearly be the duty of the superior courts to resist in defense of the Constitution. The aspect of the franchise and of the form of the government are fundamental features of a Constitution, and to alter them in limine in order to placate or secure the support of few persons would appear to be equivalent not to bringing the given Constitution into force, but to bringing into effect and altered or a different Constitution. So, sir, in this case, in that case, it was violation, it was protection of certain ministers. My lord, now
What
issue,
was the effect?
now
What
issue
of the vote क्या था? वो तो petition
जी।
तो dismiss की उन्होंने, whether they saved the amendment under Article 224.
नहीं पहले ढाका ने खत्म की, ढाका, और वो ढाका का फैसला आप हो गया यहाँ। तो यहाँ पे सर
हम तो देखिए
हमारे सामने
अभी तो हेयरिंग ऑफ द कॉन्स्टिट्यूशनल अमेंडमेंट पर पहुंचे ही नहीं है हम
ये 191
बेंच पे
191A जो है ये अमेंडमेंट ही तो है। और मैं ये कह रहा हूँ कि हमारे सामने वी हैव द बिगर क्वेश्चन बिफोर अस, इट्स अ सर्वाइवल ऑफ
I think what senior member wants to communicate you, that when the time will come, when you will start your argument on varies of the constitutional amendment, obviously this court will hear. We are not saying that we are bound that since we have been constituted under Article 191 as a constitutional bench, we cannot hear the case of varies. We can, but provided you start your argument, when you will start your argument on 26th amendment, we will wholeheartedly hear you your case.
मैंने सर ये इसलिए यहाँ पढ़ा है कि यहाँ पे एक क्वेश्चन हुआ था किसी मेरे दोस्त के ऊपर कि whether we like it or not, 26th Amendment has been passed. Now it is a part of the Constitution. We cannot do anything. So मैं ये अर्ज कर रहा
ये तो
हूँ
किसी ने नहीं कहा यहाँ
We
पे
cannot do anything नहीं कहा.
Hearing
हमने कहा whether right or wrong it has become part
I
of the
stand corrected.
Constitution.
मेरा ख्याल था कि शायद I stand
Unless it is
corrected.
शायद थोड़ी
declared otherwise.
I stand
there was
corrected.
some misunderstanding maybe,
Maybe.
but there is nothing like that, because we in the very initial day we asked all the learned counsel, they start your arguments on the amendment, but they say that there are certain applications for constituting the full court and the live stream. That is why the matter is being heard.
I stand corrected, sir. Sir, one point was raised by your Lordship, Justice Mazhar. It was with reference to Article 5 of the Constitution.
Yes.
Let's read Article 5 of the Constitution. I read, with your permission, Article 5, loyalty to state and obedience to Constitution and law. Loyalty to the state is the basic duty of every citizen. Clause 2, obedience to the Constitution and law is the inviolable obligation of every citizen. No, sir, it is not by coincidence. It was designed, Article 5 designed by like that a loyalty to the state comes first as a duty, basic duty. Then comes obedience to the Constitution and law. Sir, there can be a situation where can be a conflict between the loyalty to the state and obedience to the Constitution or law. Now, this point was dealt by this court, full bench of this court in Sindh High Court versus Federation of Pakistan. PLD 2009, Supreme Court 879. First, I refer to page
बस सब कॉन्स्टिट्यूशन ऑफ बेंच पे बात हो रही है। अब असल बात तो ये नहीं कि हम कॉन्स्टिट्यूशन ऑफ बेंच पे बेंच सुने, फुल कोर्ट सुने, अब ये पता नहीं।
बस सर ये मेरा आखिरी, जस्ट गिव मी 2 मिनट,
थोड़ा कोशिश करें कंक्लूड करें।
बस मैं खत्म कर रहा हूँ आखिरी जो मैं ये, बाकी मैं नहीं छेड़ रहा।
पेज कौन सा?
सर पेज 1067। ऊपर से सर 17 लाइन पे अगर आ जाए, where it starts, we would not like to go into the circumstances in which those amendments were passed, but we would certainly observe that the amendments made by an authority not mentioned in the Constitution and otherwise, then in accordance with the procedure prescribed in the Constitution, could hardly be given any sanctity vis-a-vis the amendments made by the Parliament in accordance with the procedure laid down in Article 230 and 239. My lords, this amendment was enacted on 21st October 2024. At that time, Senate was not complete. Senate was completed on 10th July.
ये आपके बड़े अच्छे आर्गुमेंट्स हो सकते हैं, आपके बड़े अच्छे आर्गुमेंट ये हो सकते हैं जब हम मेन केस सुनेंगे। आप प्लीज उस तरफ ना जाए ना, आप वो बाद में आपको मौका
मैं
मिलेगा।
सिर्फ सर ये कह रहा हूँ कि ये अमेंडमेंट या इस अमेंडमेंट के जरिए जो इस वक्त लॉ आपके सामने
कि
है,
इस वक्त अमेंडमेंट मौजूद, आपने खुद कहा कि
इसको वो
एक मिनट कर, आपने ये तस्लीम किया कि अमेंडमेंट नाउ पार्ट ऑफ द कॉन्स्टिट्यूशन, इसके अंदर रहते हुए आपका मेन जो आपने शुरू किया, स्टार्ट किया, आप ये कहते हैं कि बेंच और कोर्ट अलग है, तो अब आप इस पर फोकस करें कि आप ये कहना चाह रहे हैं कि इस बेंच के बजाय फुल कोर्ट सुने, दैट्स ऑल। ये आपके आर्गुमेंट्स हैं।
जी मैं यहीं पे खत्म करता हूँ सर। थैंक यू वेरी मच फॉर द पेशेंट हियरिंग।
थैंक यू। शायद आप आखिर में नहीं, नेक्स्ट वीक वैसे ही शायद। हाँ ये देख लिया अभी,
आप आपस में तय करें।
क्या वो उन्होंने